All right, good morning, everyone. Welcome to the Judicial Proceedings voting session, live streamed. We are all live now. So the folks watching, we're a little bit delayed just because folks had some trouble getting in because of the weather. So apologies for our delayed start time here. So for the committee members, we left off with the Law Enforcement Officers' Bill of Rights, Senator Carter's bill. We will start off today with Senator Jackson has offered amendments, so we'll pick up there, and then we'll move on through. I think we have maybe we have another set of amendments from Senator Bailey, so we'll entertain those and we'll keep moving. So with that, I'll toss it over to counsel to describe Senator Jackson's amendment.
So we're going off of Amendment 428078/1. I'm sorry, what? Right, it was Amendment 428078. So just to let the committee know, in preparing this, where it was possible to do so, I incorporated the amendments that the committee had already adopted in the previous voting sessions. So I'm just going to go through from the changes being made by the amendment. Start on page 5 of the bill, or page 5 of the reprint. If you look at line 9, it provides that a law enforcement officer does not include, and the new language being added is head of a law enforcement agency. So with this, the chief or sheriff would not be subject to the procedures for discipline that are provided for in the bill. Now, they would, obviously, the sheriffs are elected and the chiefs are appointed, but just to flag that for the committee.
We can just sanity check. I mean, if you have questions or comments, definitely chime in. But I mean, everyone understands generally everyone understands what's happening here. I mean, you serve at the pleasure. You're executive. Okay, got it.
So there's, at the bottom of the page, you'll see the minor policy violation language that got added in a previous voting session. Turning to page 6. There is language from the existing LEOBR pertaining to political rights of law enforcement officers and secondary employment. So it provides that a law enforcement officer has the same rights to engage in political activity as a state employee, and also that a law enforcement agency may not prohibit secondary employment by law enforcement officers, but may adopt reasonable regulations that relate to secondary employment by law enforcement officers. There are additional provisions on that subject. There's also a provision relating to the disclosure of an item of the law enforcement officer's property, income, assets, source of income, debts, or personal or domestic expenditures, including those of a member of the law enforcement officer's family or household, unless the information is necessary to investigate a possible conflict of interest, or the disclosure is required by federal or state law. So that's the substance there. I'm happy to go through the additional language that's in there if the committee would like, but otherwise I'll move on. Verbatim from the existing. Right. So turning to the next page, there is a change to the provision relating to investigations. So You may recall that the bill as it's drafted provides that in order to discipline a law enforcement officer, the department needs to investigate the alleged misconduct. The exception to this is that if they wouldn't be required to investigate if the law enforcement officer has been convicted or received probation before judgment for a criminal offense. So what this does is it provides that unless the law enforcement officer has been convicted of or received probation before judgment for a crime committed in the execution of the law enforcement officer's duties, or a crime that involves fraud or deception or that bears on the law enforcement officer's credibility, integrity, or honesty, those are the circumstances when an investigation would not be required and discipline could be imposed without going through the procedures of the subtitle here.
Are we supposed to wait for the whole thing, or do we want to address, please forgive me, I'm sorry. Excuse me, Mr. Chair. Are we supposed to just wait for the entire thing, or do you want to address issues as they're announced?
No, go ahead and, since a lot of these are consensus, but there are some touch points, so go ahead and address. It seems like up to this point, we've been pretty consensus, so go ahead and address.
Thank you. I didn't realize they were consensus because I actually had questions and concerns
Yeah.
about each one so far.
Oh, really? Okay.
So the first one was political rights. It was kind of read together, political rights and secondary employment. And my question and concern about that is those are already, political rights, First Amendment rights are already there. Like, what is the need to spell it out in the bill?
So it's funny I had the conversation, but go ahead. Senator Huff has a comment on that.
Yeah, I actually thought we're just reinstating a section that I thought was non-controversial that includes whistleblower protection, and the reasoning and the history of the political rights is because chiefs and sheriffs used to actually prohibit them from doing political activity. So sheriffs can be obviously run for office, and so they would love to say their deputies can't run for office, they can't take part in political campaigns, and so I think that was an important protection to reinstate back to them. And quite frankly,
But my question isn't about whether it's necessary, because I don't have a problem with it. My question is, why must it be spelled out in the bill?
because it was used in the past as part of their duty to say the local departments were saying that if you are a police officer, you cannot take part in these campaigns. They were saying you cannot be politically active. You can't do this stuff. Not even talking about, I see Senator Jackson has a light on. He can, as elected sheriff, probably give a better example to me, but there was a historical reason in this that when they were off duty, they were prohibited. So they were being treated like federal employees were as far as prohibiting their political activity, and they're being punished that way. And so that's why it was important that was in the law.
But for other state employees, is it spelled out in their
There hasn't been a history of restrictions. I mean, heck, look at the largest spending group down here in Annapolis is the teachers union. And so I don't even know why this is that issue. We would never,
That's what I'm saying. Like, why is it an issue? Like, are teachers
because there was
prohibited?
historically, this protection and the second jobs and all of these were historically used against rank and file officers. So that's why these had to be put in the law. In the 50s and 60s, they were prohibiting rank and file officers from participating in campaigns. Sheriffs had political reasons because they didn't want anyone challenging them or messing with them. And people had different reasons for why they were prohibiting them. So there's historical precedent for all of these why they're in there. And that rank and file officers were being prohibited that right.
But they are not currently prohibited.
They're not currently because the law says they can't. This law has been enshrined.
Other state employees are not prohibited. So my question is still, and this is not one of the most contentious issues. I don't have a problem with the fact that they shouldn't be prohibited. I just don't believe it's spelled out for other state employees. Why must it be spelled out in this?
Because there's a
petition?
historical precedent prior to the enactment of this law of this prohibition being used against them, and this law stopped it. And when you get rid of that, you will then, in my opinion, return to that.
Senator Jackson, I want Senator Jackson to get it.
Yeah, so thank you, Mr. Chairman, and thank you for the question, Senator Carter. I'm a classic case of that. So when I ran for sheriff, I was the FOP president. But while a part of the FOP, we actually went to work on the Eastern Shore in Dorchester County, Kent County, and in that region of the state, because those deputies and police officers over there were being fired by sheriffs and chiefs if they didn't support that sheriff or chief in political campaigns, even off duty. So we worked, and we actually got those agencies to offer them under the Employee Protection of Merit employee status. In sheriff's offices, you have your appointees who serve at the pleasure of the sheriff. And so when it comes campaign time, there have been cases where sheriffs would fire folks or would punitively punish folks. So that's why that was originally placed in, and that's why we're asking that it comes back in.
But from what you're saying, Jackson, during your tenure, you were able to engage in political activity.
It's because of the provision that was in the bill that was actually stricken from your version of the bill.
So I will just say, just like it's not necessary to have it in the personnel law for other state employees, they are not prohibited. I don't believe it's necessary, but I will not, to me, it's like we're not here to rewrite the Law Enforcement Officer Bill of Rights. We're here to repeal that and create a fair disciplinary scheme for officers that is more akin to what other public employees have, because they don't, it's not stated specifically for other public employees. I still don't see the need that we have to spell it out here, but that being said, it's far from the worst of the things I've heard today. I mean, I agree that they shouldn't be prohibited. I just don't think we need to put it in the bill.
Look, and so I understand what you're saying, but having lived that, I know how that works. As well as for secondary employment, there were agencies where, while they weren't prohibited from working, in some agencies you had sheriffs and chiefs making the part-time run through them before it went to the officer. So if you knew someone who had a car dealership and they said, hey, we're having problems with people vandalizing the vehicles, can you apply through your agency to be able to work part-time for my facility? What was happening with some of these sheriffs and chiefs is they would say, sure, Mike, I'll let you work there, but that's got to run through the agency. We're going to bring that money into the agency. We're going to do a convoluted opportunity. So I just think that this...
Like corruption. It doesn't sound like that a prohibition against secondary employment. It seems like, controlling secondary employment.
I understand what you're saying. So all we're asking is that the original provisions be replaced into the piece of legislation, just a protective measure. That's it.
I will simply say that I don't have a major problem with it, but I will say that I believe that most likely the actual head of the agency is in the best position to be able to determine whether or not secondary employment is appropriate for agencies that we hear about all the time, where officers are sparse and they can't get enough officers, and officers are having to do overtime and double time. Perhaps in those instances, secondary employment wouldn't be prudent. So I'm simply going to say that I think it should actually be up to the head of the agency whether or not it's okay. But again, at the end of the day, it's not the worst of your amendments.
Actually, and lastly, actually, the bill does specify it's still up to the agency head. It's just, we're just trying to take out the prohibitive component to it. So, thank you, Chair.
A blanket prohibition against it.
Yes.
I just want to all right, I know that, but because, and Cassie, you may probably say this, but you're probably going to say that these protections are in the state personnel article. And I mean, I see you
what I was going to say is that these are not state. I mean, while it's true that this applies to the state police, they are a very small subset of law enforcement officers. Most of the law enforcement officers, overwhelmingly a state, are not state employees. They're not covered by the state personnel article. They're covered by local county codes. And a sheriff could very easily say, listen, we don't let judges are part of the criminal justice system. We don't let them politic because it's unseemly to have judge politic. Well, guess what? I can apply that same logic to my sheriff's deputies and say it's unseemly to have sheriff's deputies out doing politicking. So no politicking if it doesn't favor me. So, I mean, you don't have to say it that way, but you can. So the whole idea here was that this was happening, and the sheriff doesn't have to be able to say that. They could very easily justify this by, hey, judges don't do it. We don't do it, gentlemen, ladies and gentlemen. It's not seemingly. We stay out of the fight. And this is saying, no, that's not true. And the same thing with secondary employment, that a lot of these departments are fairly small departments, and that's the key part of the LEOBR concept, was that it's not a state agency. It doesn't fall under the state police rubrics for the most part in their daily activities. And this was an intent to give some level of consistency around the state to how cops were treated, so that we didn't have in every little of the 157 municipalities, people kind of setting up arbitrary rules just because that chief felt like doing this, and this chief felt like doing this, and that sheriff is over there. So this just sets a ground rule that's logical, and I think that is important to have that. So all the cops around the whole state say, hey, here's the rule, and if it doesn't make sense to have secondary employment, the chief has discretion. They can adopt certain restrictions on it. But there's no stated prohibition against it. And let's face it, a lot of cops are part-time realtors or do some stocking in Home Depot and that kind of stuff. So
Again, I don't have a problem with their right. Here's my issue, and really quickly, and I'm going to move on because I don't want to belabor this part.
No, you don't want this bill to be about law enforcement.
No, I don't think it's necessary to say that we don't allow a prohibition that I believe is an unconstitutional prohibition. I think it's actually unconstitutional to say, nope, you can't.
But do you really think that Officer Jones, who lives in Upper Marlboro, is going to go ahead and file a case in state court or federal court because his sheriff said
I don't.
do it?
I don't
He's
think
more
so.
likely to walk over and let himself be trounced upon until that goes up to the Supreme Court. So this is just saying, this is our state policy. You don't have to get a lawyer. You don't have to go to the Court of Appeals. You don't have to go to the U.S. Court of Appeals. It's already done. Boom, it's done. It's stated, and there it is.
Okay, look, I got it. This is not the most contentious issue. I think, actually, you're both right. And just to clean this whole conversation up, I mean, this is in the state personnel article, like the political activity section 2-304. I'll just read one little section. So public policy, employee rights, you go down, there's political rights employed by state. You accept as other words provided by this section of federal state. A federal law, state employee may freely participate in political activity and express political opinion and may not be required to provide any political service. And it goes on. So, I mean, there are similar protections. That's in the state personnel.
Is that for county employees, though?
No, state.
So
Yeah.
this extends to county and municipal police.
No, I get it. No,
So
I'm saying.
there's your extra protection, and the government does on federal employees. We do under the Hyde Amendment restrict. So the government can restrict your ability to be politically active if you're highly
And
restricted under the
Hatch Act.
Hatch. I'm sorry, I said
Hatch Act.
Hyde.
Yeah.
If you're under the Hatch Act,
That's a different one. That's very different, yeah.
Hyde's a very good amendment, but Hatch, if you
That's terrible.
under Hatch, very heavily restricted, you're completely restricted. You're not putting a yard sign in front of your house or anything. So it is constitutional. They can restrict it, and this would
fine.
put the same thing to local law enforcement. Look, these folks are active. Firefighters, unions, they're all active. These people are active. We shouldn't have a different restriction on these police.
I agree. I just don't think there is one, and we can move on. I don't think there is a restriction. I don't have a problem with it.
All right, let's move on. Excellent.
But, so the next one, that's where I really did kind of have a concern.
Okay.
The one about disclosure of income and expenditures. And the reason that I have a concern about that is I don't know. So in many agencies, especially those that have like these specialized groups, specialized factions like the Gun Trace Task Force, for example, and even the former Commissioner Darrell D'Souza, who had to go to prison for tax fraud, had their income and assets had to be disclosed, perhaps they wouldn't have been able to get away with all of the money laundering and other things that they did after they robbed, a lot of the people. So I don't understand, I don't agree that there should be no disclosure for these things.
Senator Billy. Senator Jackson.
Yeah, I think Senator Carter, you speak of Darrell D'Souza. Look, so in agencies, appointees, folks that serve at the pleasure, there's already stipulation that they have to file their financial disclosures. As far as officers, so are you saying if my wife is a successful business person and I'm a patrol officer that we shouldn't be able to live in a particular house? I think that's sort of a violation to say, hey, Mike, I don't think you ought to be able to afford to live in that community. Or is it I don't have any issue if there's something that's, you believe that's nefarious going on and it's a part of some sort of investigation, that's one thing. But to have that a rank and file officer disclose their salary, they may work 2 or 3 different jobs.
Well, what about not just a regular beat cop or patrol officer, but what about command staff, and what about people that are in specialized units, like specific drug enforcement units and specific, those units where it is very easy to hide money, to steal money from, from suspects and drug dealers?
I got you. So
What about the ones that are, so my question is about the specialized units and the drug enforcement police and the command staff.
Can I ask,
I got you.
before you
So-
answer that, Senator Jeff, can I add just a tag on to that? It's just, when that's happening, when you're going into one of these specialized units, are there additional, background checks or anything? How does that process work? Are you screened? Is there additional screening that
It
happens?
depends on the agency, but yeah, I mean, when a person goes into a specialized unit, I mean, look, we do, there are cursory checks on folks. So one thing, even when you get hired as a law enforcement officer, and periodically, I think when you go into certain units, on my agency, it's like, if Mike Jackson is having some credit problems, I probably don't want him in the drug enforcement unit, I probably don't want him in certain units. But I can, oftentimes when a lot of the monies are made when you're in specialized units, and this goes back to a management and leadership issue, if there is a drug raid or if there is a case that you're working on, if you look at the amount of hours that are gathered, members of an entire unit on this particular case, they have an enormous amount of overtime hours or court time hours, because I became a supplemental, I created, I filled out a supplemental report, and so I am now going to go to court as well to say I was a part of the scene, and I may have just rolled up at the end of the event. And so these guys get a lot of that court time, so that's where a lot of that extra money comes from.
So that will be disclosed, right? So it wouldn't be a problem, because they'd be like, oh, I have all this money because I did, 50 extra hours of overtime a week.
No, I mean, so I guess my concern is, why are you asking about the amount of money I'm making? So I make so much as a sergeant. So so are you asking that every officer or every supervisor and manager has to disclose to do a financial disclosure? Or are you talking about appointees? Appointees are different.
Appointees are out because they already do the disclosures, like you pointed out.
Right.
Even though Darrell D'Souza wasn't always a commissioner, he had, at one point, worked at lower rank levels.
Right.
Detective Herschel, one of the gun trace task force, never showed up at work for about a year. He was building his own house. I think in a
That's like a
situation,
management issue, though, right? That's like a management and accountability issue.
but perhaps if they had been required to do disclosures of the overtime that they were stealing and lying about, maybe that would have been helpful.
Well, I would counter that. I would only counter that if that supervisor did his job, his or her job, to know where Mike
Clearly,
Jackson.
we can't depend on that. So I'm gonna take it or leave it. I don't think most likely these should be required for rank and file, just like they're never required for low-level employees anywhere. But I do think that there should be consideration given to command staff and to officers that work in specialized unit, particularly to deal with drugs and guns, like the Gun Trace Task Force did, because notoriously it's a recipe for potential abuse and corruption. There's also been a lot of issues with many different officers over many years with abuse of overtime, and padding their payroll, whatever. So I think that there should be some consideration given to the command staff and specialized drug unit officers in terms of requiring disclosures.
Senator Huffman and Senator Bailey, Senator Huffman.
So this really only does apply, Senator, to the rank and file. When you work at the pleasure, so if you were somebody that was, let's say, state police, a captain or higher, you work at the pleasure, you're already required under state requirements to file a disclosure. And as we all know, I mean, if we just look around the General Assembly and we look at people's salary, they're all public to start with. right? So you can look and see, when we're talking about the state, what anybody made. But when you get up in the higher rank and file, they're already required to do a full disclosure.
Thank you, that's what I said. But I'm saying there's a layer before you get to the high rank people. And there's also the specialized unit. So again, we don't have to belabor this. I don't agree that all of them should be excluded from disclosure. That's my opinion.
If we're going to look at public disclosure, financial disclosure laws, maybe we need to do a broader look and include the state's attorneys. I've noticed there's been some issues about trips and outside income in some of our state's attorneys that probably we should address as well. So maybe we can do a broader bill.
So actually, the state's attorney already is required to file disclosures because, again, like you all have said, elected and appointed officials all have to.
Sure.
That's
Well,
really not an issue
maybe,
for the bill.
Maybe we can pull the Inspector General reports with some of the problems that are coming up with our state's attorneys.
But that doesn't have
And
anything
we
to do
can
with
do
the
a
bill.
broader
Like,
bill.
you know, pointing fingers
All right,
at
all right,
outside
all right,
people
all right,
outside the
all
bill.
right.
The question is,
You
do
got
we want to really
Let's-
use this opportunity to ensure greater accountability and integrity or not? And I just think this is one aspect where we could actually make a difference.
All right, let's stay on point here. Senator Castley.
Just really quickly, Mr. Chairman. So the police officer, we already know what his salary is and what his benefits are for the leaders of his department. We know what his salary and benefits are. We also know what his secondary employment is, and because of that, we would know what his salary and benefits are for his secondary employment, which we got to improve. And this does not prevent, it does allow that disclosure of property is necessary to investigate possible conflict of interest with respect to performance law enforcement officers' official duties. So you can still get that for the rank and file. And then if you look at what we're not including is, for us, we don't have to disclose or all of our debts unless the debts are to certain entities to show that we don't have a conflict. And we don't even have to disclose all of our assets unless there's they're in certain held in a certain fashion. So what the idea here is that you're not going to be able to rape and pillage on these guys' personal information. So I think it's a pretty reasonable restriction, and I share your concern, Senator, that maybe we should look at law enforcement officers a little more closely than other public employees because of their inherent powers. But I think we do that. I mean, that's the gist of the rest of this bill, because they are subject to investigation of every aspect of their lives, and that's the rest of the bill. But at some point, we do have to treat them somewhat fairly, and to say that if you're a cop, you got to come and take your clothes off and let the whole world see. I think that's all this is doing. It's not. You got to take what this does with everything else. And when you look at everything else, we can't have corruption in the police departments. I'm totally with you on that. But if it's a totality that we got to look at, and at some point we got to be careful not to go too far and just become blatantly disrespectful and unfair. So I think this is a good protection on the balance. Thank you.
To the amendment, we can entertain it now or later, which is that this would not apply to command staff and those that are in specialized drug enforcement units, that they would be required to disclose. That would be my suggestion.
Let's go ahead and let's deal with the merits of this, and we'll come back to that. Senator Carter, can you just make a note here? We'll come back to that. Command staff. Senator Bailey, did you have something to say, or you're good? Oh, you're good. Okay. All right.
Like, I agree some of the stuff might not be necessary, but I think some disclosure might be helpful. And then next.
We're moving on.
Okay, I don't want to be the only one, pushing back on some of this, but I really had a problem with, I think it's number 4, as Jamie said. The rationale for why there would not need to be an additional investigation where there's been a conviction in a criminal court is because the standard in the criminal court is a standard of beyond a reasonable doubt, which is a much tougher standard than any agency. And if an officer has been found guilty beyond a reasonable doubt in a criminal court, and even if they've received a probation before judgment, which requires an underlying finding of guilt, then we don't need to make exceptions. It's been determined in a criminal court, there's guilt. There should not need to be a second investigation as to whether or not this happened. That, I feel most strongly about that one, for the record. It's the fourth that he mentioned, and I was unable to keep up exactly with the page, but I can find it. It was investigations into misconduct.
Yeah, it's 3-105.
It's
on-
just after, there's no page number on the page, but it's after bill page 6 of the reprint. Says that unless the law enforcement officer has been convicted of or received probation before judgment for a crime committed in the execution of the law enforcement officer's duties, or a crime that involves fraud or deception, or that bears on the law enforcement officer's credibility, integrity, or honesty, before imposing any disciplinary action related to misconduct by a law enforcement officer, the agency shall investigate the alleged misconduct. Provides that chief can, or the chief's designee, if otherwise authorized, can impose discipline against a law enforcement officer without first conducting an investigation if they've been convicted or received probation before judgment for any of those offenses.
So actually, the first part, striking the first part of this makes sense, because I don't think, because it's, the facts have already been determined. There's already been an adjudication. There's already been a finding of guilt. So why do you need to reinvestigate that? So that's, I mean, that makes sense to strike that, actually. Because that doesn't do what you all, I mean, that doesn't deal with the actual, like, process that the chief is going to go through in determining what they're going to do. And it doesn't deal with what the offenses are eligible for discipline. It just deals with the fact that there's already been an adjudication.
Well, not really, because this is PBJs.
No, but what I'm saying is that, but the facts have already been determined before.
Senator Carter always argues for everybody else.
Yeah, hold on, let's do this, Senator Casserly and then, Senator Jackson.
So I want to place Senator Carter in her normal role here, where she would say, but wait a second, this might have been a case where there was an allegation of domestic abuse or an allegation of maybe it's a DUI case, and you have an officer there, and they're saying, look, his lawyer says, I know you say you didn't do this, but you're punishable by up to 3 years in jail on this offense. The state attorney's offering you a deal. A PBJ, you plead guilty, you get a PBJ, you do 20 hours of community service, and you're done. Or you roll the dice, and you can go to jail. And he's like, that's terrible. And that would be for these but that only apply for these matters. If he does that, and it's for, under the way the bill's written, the amendment's written, if it's a crime committed in the execution of his duties, or involves fraud or deceit that bears on his credibility, integrity, and honesty, it doesn't matter. He takes a PBJ, he just signed he better just stand there and take the trial, because if he gets it, he gets the administrative penalty as well. But we do have to, these guys do have lives outside of all this. And if everything that comes up, the neighborhood assault, where he was, in supposedly, some sort of altercation in a bar or something, that's not in the course of his duties, and you got to give, there's no reason we should make police officers say, oh my gosh, if I take the PBJ, I'm going to lose my job, because it's going to automatically be that I am a batterer and I get in fights. Instead of the cop, the judge may say, I find both of you, we'll give you PBJ, but I find both of you are the aggressors in this bar fight. And the cop's going to say, I can't do that. I got to take the trial. I can't take the 10 hours of community service, Your Honor, because it'll be de facto that I beat people up, as was alleged, and I can't have it on my record, or I lose my job.
Well, I think I'm trying to understand the objection to this portion here. So typically, what happens is, if I'm charged criminally for something, I jumped over the fence of my neighbor, or something happened, he keeps cutting my grass, we can't get it settled, and I do that. There are provisions that, conduct on becoming of an officer. So once that's adjudicated or whatever you do, then the agency then looks at it to say, Mike Jackson, does that fall in line with conduct becoming an officer? So, I mean, there are a number of catch mechanisms here if agencies do what they're supposed to do. So I'm trying to understand are you asking that not be in this provision?
So, thank you. I thought about that as kind of like a catch-all is maybe if an agency has a role for conduct unbecoming, but my concern, like what Senator Castley said initially, was that if there's a guilty finding or a PBJ, but it's something so innocuous that it doesn't even violate, it's not even misconduct under the agency rules, then it wouldn't apply. But if it is a violation, the legislation as it stands without this amendment doesn't require a chief to issue discipline. It just says the chief doesn't have to re-adjudicate those facts or investigate because there's been a determination. So the chief could choose to not discipline, to discipline, or to hear mitigation as to what occurred, just simply not conduct a full investigation. That's my reading of the bill without the amendment. I think it's a better bill without the particular amendment, and I don't think the amendment is necessary. I think it weakens the bill.
Just to be clear, this isn't the decision point for when and how a chief can discipline an officer. This is just about the investigation. I'm trying to figure out why there's an additional investigation that's required.
Because if the officer, let's say it's a domestic dispute, and it's criminally charged, and he just, or she, let's take the she's criminally charged, and rather than take the risk of jail time, she takes a probation before judgment. She says, look, he was the aggressor, but I realize it's a he said, she said thing. The judge is going to make the ruling here, and then I'm screwed. It's a battery, which means if it comes before the chief and it says Officer Sheila Jones committed a battery, he's got to nail her because you can't have
I'd
cops
strongly
going around.
advise the officer to take an Alfred plea if I were the officer's lawyer. But I want to, what the chairman said, this bill isn't saying that there will or won't be discipline. It just says there doesn't have to be an investigation into what happened. I contend that this doesn't preclude the officer from offering mitigation because this bill allows for mitigation to be presented before discipline is imposed. Just simply, there doesn't have to be an investigation into the facts.
If this was anybody as a defendant other than a police officer, you'd be arguing exactly the other side of this, which is that now you have a chief who's got officers with battery offenses, and then the local council says, wait a minute, you got 3 officers that have been guilty of battery. You're a terrible chief. And he says, well, but if he doesn't have his own hearing to say what really happened here, that's not a mitigation. It's to say, did you actually batter that person? I know you took the PBJ, but now we're in administrative realm, and for any other state employee or any state employee, this would not be a res judicata effect. They would not be bound by this. If they're coming before in any other event, they would still be entitled to their hearing. So we are treating police worse, and what we're saying is, just because it happened in your outside life, things are going to happen, and you shouldn't be bound by that decision, and you should be able to come forward and be able to have a hearing on what, and not just mitigation, because mitigation is just, well, I'm a nice person.
So again, like Chairman said, an investigation is not a hearing, but I will say if we were talking about a hearing, here's what would happen.
Well, it's a hearing.
This is a true test copy of your conviction for this? Okay, prima facie evidence that you did it, ready to decide. So I don't think that. My point is that, though, what the chairman said repeatedly, we're talking about no need to reinvestigate whether or not it occurred. We can presume it occurred because there's a guilty finding, and even a PBJ can only be entered once the judge finds guilty and then says, I'm going to strike the guilty finding. So thus, that's proof, true test proof that it happened. No,
and we agree with that.
Do I think every guilty finding is because somebody actually didn't know? But that's not what we're here to litigate.
On all these matters that are listed, we agree with that it's a crime committed in the execution of their duties, or that involves fraud, deceit, or that bears on the law enforcement officer's credibility, integrity, or honesty. And all we're pulling out here is a much smaller subset of things. All the major stuff that you want to nail this guy or gal for, it's already raised to, they're already, it falls in. And what we're pulling out with this is the minor stuff, the petty stuff. that says this was petty, this was, everything, all the things that you're saying really make a bad cop, we're saying you're right, he's bound by it. The stuff that you would really say, oh my God, we're done with you. You lied. You committed fraud in your job or something like that. We're already saying you're done. It doesn't need another hearing. This is 90% of everything you want. I think it's 100% of everything you want. You really want to be holding people to say, a domestic dispute or I mean, of course, if it gets too bad, then it's a felony and he's in jail anyway, so it's all's lost. But if it's, neighborhood squabbles, you really want to pull all that nonsense, not nonsense, but all that stuff in. So I think you've got what you want here. All that major stuff is in the bill. It is res judicata. We run with it, and we're really talking those minor things that I ought to be able to say something else.
I just want to parse out, because this piece is less important than the second part, which is the subpart number 2, which is where the chief is authorized to take action under certain circumstances. Now, the first part, I got to tell you, I just don't understand why you have to do another investigation on something that's already been determined by another tribunal. Yes. So the second part, lines 27 through 30, that's the meat. I mean, this is when the chief is authorized to take the action. And that's, I think, the more contentious part of this amendment, frankly.
He just moves forward and imposes it. What's contentious about the rest of it?
Well, this is because before, in the LEOBR, it's like a felony, right? It's just a felony. The chief can take this disciplinary action. You can tell me. I don't know if Jamie has I don't have the line by line with the current statute, but without first conducting an investigation. I mean, that's the more important part to me. But
I'm sorry, which because it says
so for 27 on this page.
27.
Yeah, all the way down through the next page.
It leaves out what?
I'm not saying it leaves anything out. I'm saying that's the more contentious part.
Why? That says that if he did one of those things, you just go right to the punishment phase
Yeah.
of it.
And we're changing that. So before it was just a criminal offense, and now it's committed in the execution of a law enforcement officer's duties or a crime that involves fraud, deception. You're providing qualifiers there, whereas before.
80% of the qualifiers, though, are, yeah, and the qualifiers are like 85% of things. I mean, Senator Bailey had one too, in that it shouldn't be 100% of things. I mean, we're talking like traffic offenses. I mean, we're getting into everything. So I think that is so broad. I struggle to think of very few things that it would encompass. I mean, it affects their honesty, trustworthiness.
No, this came up in the hearing with the misdemeanor, everything from a traffic ticket to, but also.
I mean, but this is
possession.
so broad. It's basically the chief's discretion to say. I mean, this is very, very broad. Other than just what the original book came in and said everything and anything, and this says 90% of everything and anything, and it's the chief's discretion. He could actually say, well, your speeding shows you're not obeying the law and you're not trustworthy, so I'm going to just go ahead and put discipline in. So, but it does establish some very minor, small barrier. I mean, I think this isn't even what Senator Bailey originally had, which was basically gun disqualifiers. Remember, this is them just being able to straight up just slap on discipline and go around the rest of the procedure. So, I mean, I think this amendment it's very broad now.
Look, so there obviously, because some folks are treated differently, unfortunately, but progressive discipline has to be available. So, just because I'm speeding up and down the highway doesn't mean I need to go to a trial board. I can actually, as a sheriff, I can take your car from you if it's substantiated. So, I think I think it's a good piece of the amendment. So, can we
All right, I just wanted to make sure that, I mean, the focus should be on that second part, not the first. But anyway, Senator Hedelman.
Thank you, Mr. Chairman. I have a question. Even in the second part, where does domestic violence fall? Does that fall into the bucket of fraud, deception, or that bears on the law enforcement officer's credibility, integrity, or honesty? Because I do think, and I don't subscribe to the scenario that you outlined, because I think it's entirely relevant to a police officer's ability to do his or her job about whether they personally have been involved in a domestic dispute. And I don't want to have that be outside. I mean, that should be considered. And I guess, yeah, if Senator Jackson could respond to that, does that fall in that bucket?
Absolutely. There have been members who have been dismissed from service because of that. You cannot commit an assault, but you can't batter someone. And so, yeah, it falls there. And I think, yeah, absolutely.
Okay, so then I agree with Senator Carter in the first part and the chairman.
No.
Our laws recognize certain crimes or acts as bearing on credibility and honesty, and those generally have to do with theft, theft schemes, bad checks, things that show moral turpitude. I don't believe
Lying.
that domestic violence has ever been considered under any law or case law a crime of moral turpitude. I mean, correct me if I'm wrong. So I don't think so.
Well,
This
is the dispute. I mean, because I think that's entirely relevant to consideration in this section.
even assault outside of domestic.
It's a crime.
Well, I mean,
Specific provisions in the domestic violence statute that address this, because once the law enforcement officer has been found with domestic violence, then he can no longer carry his handgun, and therefore he's removed from duty. And so we don't really, I mean, now you don't have your weapon, and you're kind of not of any use to anybody in the law enforcement agency. So that's the whole issue. I mean, it's dealt with specifically in the DV statute.
right, but with regard to what your scenario in PDJ, I mean, that's what I do think it is important to include what Senator Carter was talking about in the first part.
But so you would still
Let
go
me say this.
after them.
If I might say this.
You can still go
let me
after
say
them
this.
with a hearing.
So,
Everything's on the floor. The chief can go after.
Right, but we're talking about the investigation piece, whether you need to reopen an investigation.
Whether you reopen it and say, let me hear what you said. Let me have more evidence on this, because you got into district court and all you did was say, okay, I'll plead guilty and take the PBJ and walk. Did anything come into the court? No, I just said
But that's the process that we have.
for on the criminal side.
Right.
Yeah, I got it, and that's fine. I'm fine with it on the criminal
Senator-
side.
Senator
The issue is,
Heldman?
do I lose my job for that? Because nobody else in society
You're
would
not
lose their
losing your
job.
job.
for
You're determining whether
Senator-
we need to have another investigation.
Mr. Chairman. So look. So let me see if I can kind of wrap this up. So when I was the sheriff of Prince George's County, our signature was domestic violence unit, the first in the Mid-Atlantic region of the country that had a 24/7 unit, sworn civilian and volunteers and what have you. So you know, by law, you are not able to carry a weapon if you are convicted, right? But we've also had provisions over the years that were placed into the law that would not allow that a domestic partner to go in and drop that case. So my troops weren't let off because of they weren't going to get a slap on the wrist in that. We take that very seriously. So I'm not sure where, to me, that is a crime. So I think, I'm not sure. No one's going to get off for domestic abuse, child abuse, or anything else. The key is, if you are found guilty in a court of law, then there's also an administrative process that goes, regardless of what happened in that court case. If you come to my house and my wife and I got into some sort of spat, there's a report filed. Guess what? My agency gets a copy of that report. So we're going to wait for the adjudication of that, and now investigators in the agency are preparing for the administrative hearing regarding that matter. The result of that matter, once we have the result of that matter, disposition, then we move forward with our administrative hearing. Even if that case didn't go forward, it doesn't matter what it is, there's still some aspects of who you are as a law enforcement officer that you cannot conduct yourself in certain manners off duty. And so, trust me, they aren't going to be able to walk away from that. There are commanders who have lost their jobs because of those things. So
I hear you, but I agree with what the chairman and what the senator said about we're just talking about this investigation piece.
So if we start a list, so what do you asking? So you're asking to list everything?
No.
We're saying that if there's been a criminal adjudication and a guilty finding, or the underlying finding of guilt, the chief doesn't have to re-investigate that matter. It doesn't take away what you're talking about a hearing, because if it gets to the point of a hearing, then that is going to be used as evidence in the hearing. There's just not a re-investigation.
I think the administrative hearings are.
There was no adjudication,
The
Mr.
administrative
Court.
hearings
You walked
are-
in and you said, here's the charge, are you guilty? If you went to PBJ, all you do is say, I accept the PBJ.
We generally
There was no
consider,
investigation. It was an allegation
just wanna
and you
say that's
accept
never
it.
done.
That's it. There's no
I don't think
investigation.
we're going
And
to
all we're
start
saying is
claiming
that
that. Are we going to start claiming that there's been no adjudication, that there's been no finding on the merits, that there's been no criminal conviction? Because the court has to find, even if it's just a recitation of the facts and a plea, the court must find guilt beyond a reasonable doubt before they can enter a PBJ. Unless we change the law, that's the law.
why do we go to all this effort to expunge PBJs and the like? Because I don't get it. Because if those people,
Because
they
they're
all say
designed
they
to give
did it,
people a
so they
second
did those
chance.
steps. So just leave this stuff on the public record. Just let everybody know that 10 years ago Jeremy stole $500 and he's a thief. Just let him go. But we say, well, but it was a PBJ, and he only took the PBJ because Jeremy didn't want to go to jail because he realizes that he may have gone to jail, so he took a PBJ. And we do that all the time for the other side. Every time we get on the criminal law side, we always say, hey, people get pushed into these PBJs.
See, I think this is, really quickly, one more.
Senator Carter, go ahead, and then Senator Jackson, please.
I think this is covered, and I'm not. So this should give you solace. I'm not concerned about that because now I'm very into the presumption of innocence. However, if the officer comes in and the chief says, "Hey, you were found guilty of domestic violence against your wife and you took a PBJ. I don't need to investigate that, but is there anything you want to tell me?" And the officer says, "Hey, yeah, what I want to tell you is that it's not a final determination on the merits because I'm actually appealing." Well, actually, you can't appeal the PBJ. So it's a guilty finding, and I'm appealing it. Then I would say that the chief would most likely not render a final, or would not. There still would be no need to reinvestigate because you still wait for the criminal determination.
So, Mr. Chairman, and so we can move on with my amendment. I just want to say this. I still have a responsibility as the sheriff or chief of that agency to make sure that Mike Jackson, who was arrested or who was brought before, who was brought up on charges or alleged to have done something, that he still is, that he didn't violate any policies and procedures on my agency. And so, but that's after the adjudication. And so I believe that's what that's saying, that the chief will say, okay, so there was an alleged domestic at your residence the other day. Once that gets adjudicated, then we need to have a conversation with you to make sure that it's not something we need to know about, because you know what? You may have to go in a domestic hall one day. I don't need you choosing sides when you get there. I don't need you to say to the guy, hey, man, I went through this with my wife the other day. So you need to make sure of that. So I really don't think there should be an issue with that. Nice conversation. I think if we can move on, unless there's an amendment to the amendment, but I think.
Well, I'm confused. There's a single amendment that I am going to make a motion to oppose this particular amendment, because I don't agree with it.
Okay. So let's take this we're going to go through the whole thing and adopt it all or not. But Senator Cassidy, go ahead. And then,
briefly,
then we can have
open
up the conversation after that.
What you're proposing, Senator Carter, is that, so I get in the officer gets in the fight with the neighbor in the back, and he pleads guilty for the PBJ. Now it comes before the chief, and the officer in the chief's office is going to say, well, here's what really happened. And the chief's going to say, gosh, you're right. I believe you more. The neighbor was kind of a squirrely person, so don't worry about it. But that's not what you want at all. You want the hearing. You want the chief to be bound by a set of facts that the hearing board heard. Let the neighbor come in and say, no, this guy jumped over the fence and beat the crap out of me. and he's an aggressive guy, and here's what he did 3 other times. You want that hearing, because now the chief can't go on what he or she thinks the facts are, because that's all mitigation is, really, right? I don't really, so you want that hearing to say, so,
You've spaced 50 times. That's
but you want
mitigation.
that at a hearing. You want a hearing board to make that decision, where the 2 civilians and the cop are there to
I
say.
don't think this takes that away. I think it says there's no reinvestigation. But that's,
But that is the hearing under the way the bill is, that hearing board is the investigation. Maybe that's the confusion we're having right now, is you're going to come, if you look what's going to happen, the allegation, or the PBJ gets slapped on the chief's desk, and then the chief says, well, under the bill that Senator Carter approved, that amendment, I just have to accept this is true, and so I'm going to give you punishment, but you can argue for mitigation. And then the guy sits in the chief's office and says, I really didn't do it. Here's what happened. And so now it's all behind the curtain. And what you want is the chief to say, okay, look, if you want to contest this, we'll have a hearing board. What you're going to tell me in private, in mitigation, I want you to tell the public before these 2 citizens and this other cop, they're going to listen to your song, your sob story. And if they think that you're right, then those are the set of facts that I will then render punishment on. But if they tell me that, no, you were the aggressor here, you're lucky you got away with a PBJ, then I'm going to fry your butt. So I think in the interest of transparency, you want that. Of course, that doesn't apply in these other cases, because there is no mitigation. If you lied, stole, those things that are exceptions from the hearing, there is no mitigation. You were convicted of things that were so serious that don't even worry about mitigation. There's no.
serious than beating your wife? I'm just asking.
I'm sorry.
You said more serious, that's all.
No, we already said
All right,
that.
all
We
right.
already said that domestic
Okay.
violence.
Let's-
Once you get that, you lose your weapon.
Okay.
You're a cop anyway.
We all know what the amendment does. Got it. Roger that. Can we move on to the explanation of the next one, please?
Has anyone not read this, with all due respect? I mean, just to move this along, this was sent out last night. I appreciate Jamie rereading it to us. I've read the whole thing. I mean, maybe just see if people have questions about it. I mean, people were given ample time to read it. As much as I enjoy
Yeah.
Jamie having been forced to read this 20 pages to us.
No, I think we're on page 8 or 7 of 17. Just get the highlights and keep
I
going.
mean, we're almost an hour and a half.
Yeah,
in.
so let's roll, just high level. Yeah, people understand, people have got the language before them, we all understand.
So on page 7, would just qualify that for an investigation in a misconduct case being conducted by a person who's not a sworn law enforcement officer, the person would have had to have received training administered by MPTSC on investigation of misconduct committed by law enforcement officers. At the bottom of the page, there's the language that was adopted earlier about the subpoenas and the petition to the circuit court. On the next page, page 8, it's striking a provision that requires payment of a reasonable fee for reproducing the investigative file. It also strikes a provision that provided if the investigative file couldn't be provided, then the chief or the chief's designee would be providing a written summary of the facts and evidence used as the basis to conclude that the law enforcement officer committed the offense. Makes a similar change to on page 9, it provides that after conducting a review of the entire investigative file, the chief shall make a recommendation for the disciplinary action to be imposed, if any. The law enforcement officer would then accept the disciplinary action or could request a hearing under 3106. The chief is not required to review the investigatory file, and the officer is not entitled to request a hearing if, in relation to the matter or matters for which disciplinary action is being taken, the law enforcement officer has received a PBJ or been convicted of a crime committed in the execution of the law enforcement officer's duties, or a crime that involves fraud, deception, or that bears on the law enforcement officer's credibility, integrity, or honesty. There's also a provision, it's in the new subsection E, that borrows from existing language in LEOBR relating to blood and urine testing, polygraphing, and interrogations. It just provides that a law enforcement agency may order the law enforcement officer under investigation to submit to blood alcohol test, blood and breath, urine tests for CDS, and as well as polygraph examinations or interrogations that specifically relate to the subject matter of the investigation. And then there are some provisions that follow from the existing procedures under LEOBR. Sure.
Because this is a new section, just that it's not discoverable in a criminal proceeding. So then it really matters in terms of the timing of this, right?
Well, so I feel like you can't, I mean, if you compel this stuff, then you got a criminal investigation going on, you got this administrative piece going on, and like, we've had this conversation a million times, but I mean, logistically, you're not going to move forward with a lot of the administrative piece until the criminal is completed, because you don't want the
Right.
products of the administrative to taint
And this is
or
just
deprive you of
belts and
material.
suspenders?
Correct.
Okay.
Yeah.
Okay.
So moving on to page 10. It changes the process for how the hearing. I'm sorry. Oh. Sure. That's just providing that counsel or a representative. That's sort of those procedural steps. Right. There is new language on that, but that's those procedural steps on. Right. So page 10 changes the process on how a hearing board comes about. In the bill as drafted, it provides that if the chief or chief's designee determined that there was a issue of disputed fact, then the chief would order the hearing board. What this does is it provides that if the law enforcement officer requests the hearing, the chief shall order the hearing to make findings of fact and recommend discipline, if any, to be imposed by the chief. So the language about the appointment of the members of the hearing board. One other small change to note: what the amendment does is it calls it an advisory hearing board. But it's consistent with the amendment that the committee adopted earlier on the makeup of that board. So it'd be 3 individuals who had no part in the investigation, and one of them is a sworn law enforcement officer of higher rank than the law enforcement officer. Then there are 2 individuals who are civilians who've received training administered by MPTSD. So in page 12, there are amendments included that had previously been adopted by the committee, providing that the board would prepare written and proposed findings of fact, and then recommend disciplinary action, if any, to be taken against the law enforcement officer. From there, the chief, reviewing that, would have 60 days after receiving the findings of fact and recommended disciplinary action to review and determine the appropriate discipline, if any, to be imposed against the law enforcement officer. And specifically, the chief could not alter the findings of fact determined by the advisory hearing board.
What page you on that?
That was page 12. Moving into page 13, this deals with the limitations period for bringing about a disciplinary proceeding. It strikes.
Senator Sidner has a question.
Thank you. Just one quick question. And speaking with some constituents back in Baltimore County, one of the questions that came up, part of the discussion, was that if you have one of these decisions sitting on a chief's desk and they don't act in a timely manner, and with where we're going with this, do you know what would happen? I mean, if the chief doesn't act in a timely manner, does the complaint go away? I mean, I think there was some sort of a court decision on something like that this past year, where there was a discussion about timeliness of a chief's action.
So I'm not specifically sure, Senator, but I could look into that for you. I'm not familiar with that case.
Yes, the court dismissed I can't remember, like, a lot of complaints in BPD because they had failed to timely investigate. And so the statute of limitations had passed, so the court said you can't do anything about it now, it just has to go away.
Okay.
Here. When you look at on page 10, line 18, and then go down 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines below 18 on page 10, it says that 2 civilians must receive training administered by the Maryland Police Training Standards Commission on police discipline and procedures, which is different than what it says the first time in this bill on what that training is. I think this is correct, but I think where we saw it first earlier in the bill, it's different. It's on investigations. That training is on investigations. This is on police discipline and procedures, which is, I think, what we wanted to say. And the first one about investigations is a change. So in any event, they need to be the same, right?
So that addresses a different part of the amendment, where in this amendment it actually does create the new training requirement, or the MPTSC would be doing training on the investigations end, not just the adjudications end.
But these are the people, maybe I'm missing something, these are the people that have to be trained, and there's 2 individuals who have received training on discipline and. So
Right.
Wouldn't that be the only training we're mentioning in this entire bill? Would be
No,
the training?
so in this particular amendment, it's not. In this amendment, what it is it's the commission shall develop and administer
I see what it
training.
says.
I'm sorry, what?
But earlier, we talk about the training they have to have. It's
Right. So that's actually provided for towards the end of the bill, Senator. It adjusts the commission's powers and duties to require not only the existing training on. Currently, the wording is, and I'm looking just after page 16 of the reprint. It's on a unnumbered page. So it says the commission shall develop and administer a training program. This is existing law. The existing law says that it should be a training program on the LEOBR and matters relating to police procedures for citizens who intend to qualify to participate as members of.
Okay, so
hearing
I'm
board.
looking, Jimmy, I'm looking on page 7, line 12, and it says the investigation. Okay, so I get what you're saying. That's the police's investigation, and this is the hearing board's investigation. Okay, never mind.
So it's.
You're correct. I stand correct. Yeah, you're right. It's 2 different ones. Okay.
Senator West.
Thank you, Mr. Chairman. As long as we're on page 10 at this point, which is where the hearing board's composition is determined, I want to bring to the committee's attention, I just got an email from Roger Mano, which just has disappeared on my screen for some reason. Let me see if I can bring it up again. Literally, as I was about to refer to it, it went away. Never fails. It's on behalf of a bunch of labor unions, primarily out of Montgomery County, including the D.C. Maryland AFL-CIO. And I'm sorry, my computer is infected. Here it is. Roger Manu. He would like some language to be injected that says the following: for jurisdictions with exclusive collective bargaining representatives, for jurisdictions with exclusive collective bargaining representatives, they shall negotiate hearing boards to include 2 sworn law enforcement officers and 3 non-law enforcement citizens from the state of Maryland. So that would change this. It would give them the right, instead of having a committee of 2 citizens and 1 law enforcement officer, to have 3 citizens and 2 law enforcement officers if they negotiated as a part of collective bargaining.
We're going to stick on the amendment, but Senator Cassidy, go ahead.
So, the one thing that Senator Carter and I have agreed on consistently throughout this bill, so I'm not sure why we butt heads too much, because we have the overwhelming important piece of this bill is that it's not subject to collective bargaining, and we both agree, I think, very strongly on that. And she has very good reasons, and our disagreements tend to be on the more peripheral stuff. But I think that's not a bridge that we want to cross. And I think there's been extensive, if you look at the letter that I put before this committee on my bill, on my proposed amendments, which solely just start explaining exactly why and the history of that. I wrote about a 7-page letter to the committee explaining why we wanted to remove the collective bargaining exceptions in this bill, and provided ample documentation on the history of LEOBR and legislative history as well. So I don't think we want to go back in there. Thank you.
So I was just going to say, I'd really just like to try, if we could just get through this amendment and have Jane finish reading it, and then we can take up the amendment, other than amending it and
Yes,
fighting
agreed.
and debating it
But
out.
yeah, I appreciate it. Thank you.
So going to page 13 of the reprint, this affects the limitations period under the bill. So currently in the bill, a disciplinary action needs to be brought. Actually, what needs to happen is it needs to get to that stage where the investigation is complete and the officer has been notified of the offenses that he's believed to have been involved in, the potential penalties for those, and the recommended penalties. That needs to happen within 1 year of the law enforcement agency becoming aware of the act that gave rise to the disciplinary action. The exception to it under the bill is that an officer can be subject to disciplinary action at any time for an offense relating to criminal conduct or the use of excessive force. There's also 2 other exceptions. In the case of a civil suit, the disciplinary action can be brought, or that notice needs to happen within 1 year after final disposition of the civil suit, or for an offense that reasonably required more than 1 year to investigate, promptly after the investigation is completed. So what the amendment does is it strikes those last 2. So the limitations period for the civil suit and the limitations period for the investigation that reasonably required more than 1 year to complete. And just sticks to the general 1 year limitation period or the fact that it can be brought at any time for criminal conduct or excessive force. So the next change is on page 14 and provides, this relates to the chief's authority to suspend a law enforcement officer without pay. It provides that a chief or a chief's designee may suspend a law enforcement officer without pay and suspend the officer's police powers on an emergency basis if the officer is charged with a crime that is committed in the execution of the law enforcement officer's duties or a felony. So in any circumstance, a felony could result in suspension without pay. The next section that's added is a provision of the existing LEOBR. that provides that a law enforcement agency required by law to disclose information for use as impeachment or exculpatory evidence in a criminal case for the purpose of satisfying the disclosure requirement may maintain a list of law enforcement officers who've been found or alleged to have committed acts that bear on credibility, integrity, honesty, or other characteristics that would constitute exculpatory or impeachment evidence. It also incorporates a provision of amendments adopted by the committee previously relating to law enforcement officers who are absent without leave and requiring restitution. So that's out in this amendment too. And on the second to last page, provides that a person may not knowingly make a false statement, report, or complaint during the investigation or proceeding conducted under the subtitle, and provides that a person is subject to existing criminal penalties for doing so. And that actually is in the existing LEOBR.
Senator Jackson.
Yeah, Jamie, you, so in my amendment, thank you for reading through the amendment. I need to make a change on the amendment. I'd like to strike 3.1.15.
Gotcha.
From this
My mistake,
amendment.
Senator. So that's, so I guess the amendment is supposed to say on page 16 of 17, 3.1.15, which is line 14 of the page. So that section is actually intended to be stricken.
Thank you.
The only thing I'd bring up is just that last part that I mentioned about the MPTSC requirement for training. It would not only have to be training, which is under the current law on police disciplinary procedures for the folks who are going to serve on the boards, but also the investigative piece. So that would be a separate training now that they'd be required to do. Right, right. So one would apply to one and the other would apply to the other.
I'd like to move the amendment.
Second.
All right, so I got it. There has been a motion and it's been seconded. It's open for discussion. Senator Bailey, go ahead and discuss. Then I want to give Senator Carter an opportunity to speak.
Oh, I'm good. Yep.
I was just going to say, I know Senator Carter has amendments to the amendment. We need to adopt the amendment so we can work off of it before we start taking amendments to the amendment. So just for procedurally, we need to adopt this amendment so that we can work off of it.
Okay, absolutely not. I cannot believe that we just sat here and listened to an entire rewrite of the Law Enforcement Officer Bill of Rights, posited as an amendment. Okay, that's absurd. This was an entire rewrite of the Law Enforcement Officer Bill of Rights. If this is adopted as one amendment, then it is absolutely not what we intended to do with this bill. It's absurd that this bill, these amendments, read as one amendment, which should have been done separately, and by the way, are extremely late because we'd already ostensibly been told to get our amendments in long ago. And now we have something that is given to us saying it's an amendment, but then it's a whole rewrite of the Law Enforcement Officer Bill of Rights. It reinstitutes the same thing that we had in place as with trial boards. It limits an agency's ability to discipline if they don't get it done within a year. I mean, I could go on. There's probably holes that should be punched in each one of the amendments. I'm appalled that we would consider taking this as one amendment. It's a rewrite of the Law Enforcement Officer Bill of Rights. And so I think there's a motion on the table to adopt the amendment. I'll be voting against it. I'll categorically be voting against it. Had it been done the way it should have been done, as each individual thing considered separately, there might have been one or two things that might have been less offensive. But as it stands now, I would urge the committee to reject this amendment as a whole in toto. Thank you.
I'll just say this, the senator was well within his rights, and quite frankly, he introduced one amendment, which makes sense. That's the process. You have an amendment offered, there's a favorable and a second on it. I think we went through painstakingly debated this. Obviously, there's a difference. I tend to feel a number of these things, putting back in the whistleblower protections, putting in a lot of these things makes sense. We can adopt the amendment. If you have amendments to the amendment, you can go through every section and try to talk off it, but he did this right through the process. He had the amendment drafted. It was submitted last night. Everyone had plenty of time to read through it. Quite frankly, I don't like the fact we sit, I mean, Jamie sits here and reads painstakingly what I read last night and went through the whole thing. So we have, it's motion second, and we should move forward with it.
All right, everyone, we have broken for lunch. We'll reconvene at 1 o'clock. So we break for lunch now, 1 o'clock.